So our firm solely focuses on corporate immigration, and our clients break down into companies, hospitality organizations, and sports clients. I always say to our staff that our clients don't really want to hire us. If they could hire Americans, they would do that in a second. It's expensive, it's time consuming. This new administration seems to be throwing every roadblock possible at them. And if they could get away with hiring Americans, they would in a second. And you're exactly right, Mark. They can't. And so because of that, they have to turn to our firm. What's really difficult on our side is that our firm, when I created my firm, I really created it with this idea that we're going to be proactive, we're going to think ahead, and we're going to try to solve things early on. Since this new administration took effect, and really, I would say over the last 4 months is really where we're seeing the changes coming down. Unfortunately, we're telling this to our clients. We are continuing to try to be as proactive as possible. There are definitely times where we are in a reactive mode. One of the really interesting things about this new administration is that because early on, and frankly until this tax bill, they haven't really been able to get anything through, a lot of the changes they've made have been very quiet in terms of how they're interpreting the regulations. So the government has just so much discretion in how they interpret these regulations, and they're doing it very differently than past administrations. And so what we're seeing is we're filing the same petitions or the same applications, and we're getting very different decisions or requests back from the government. Ultimately, by large, we're still getting approvals, but some of the things we're seeing coming through are just mind-boggling and surprising. In the corporate world, one of the things that we have to do when we file applications is we have to explain what wage will the foreign national be making. Now, the Department of Labor has all these buckets, and to very simplify it, they have all these buckets. You can call someone at your company any title you want, as absurd as you want it to be, but at the end you have to analogize it to the Department of Labor category. Up until now, you could use the entry-level wage category for these applications, and in many examples, the entry-level wage is exactly appropriate. It might be a recent college grad that's doing a software engineering role. About 3 months ago, nationwide, the government started asking for evidence as to why are you basically using an entry-level wage for this application. And we're hearing about a lot of denials based on this entry-level wage. There's nothing in the law about this for years that's been totally fine.
Right.
And again, it's absolutely appropriate. And what's frustrating in terms of us, in terms of being an immigration lawyer, is that the world moves so quickly, and at the end of the day, and I'm speaking actually as a business owner as well, a business is only going to be willing to invest so much money in someone, especially if they don't already work at the company.
Correct.
So what's frustrating is a lot of the changes that are happening. If someone sued the government, they would probably prevail because they're completely going against the regulations. But because organizations need to move quickly, fill jobs, and they don't want to spend endless amounts of money on an individual, a lot of the stuff isn't going to be challenged.
That's a good point.
So it's an interesting time right now, and I keep saying to my wife, I feel like Trump is making me travel across the country, because one of the things that we've done is, and I've personally done, is I've gone to visit every one of our corporate clients to explain what's going on, try to explain to the employees what's happening and what they can expect, and just trying to make everyone less scared, because it's a very scary time.